Hello, welcome to today's webinar. I've just been talking to myself for 30 seconds, so apologies for the delay. I was explaining we have a new user interface and I wasn't quite sure which buttons to press. I'm hoping I've now pressed the right ones and we are broadcasting to you all. If I can ask some of you to please type into the questions box that you can actually hear us, that would be much appreciated so that we can make sure that we've pressed all the right buttons and turned on all the right settings. Great, I can see some of those. Fantastic, we can get on with today's session. That's brilliant. Today, as some of you may have noticed, I'm not Catherine Dorr. Unfortunately, she's not available today, so my name's Colin Smith. I'm one of the other partners at Brachers, and I've stepped into her shoes today. I'm accompanied by my colleague Lisa Rothon, who's going to be taking us through the first part of the session on the Employment Rights Act aspects, and I'm then going to talk about some recent case law after that. We are planning to have some time for questions at the end, assuming we get the timing correct. Hopefully we'll have 5 to 10 minutes at the end to answer some questions. With that in mind, I'll stop waffling on at the beginning and we'll make a start on today's content. I forgot to say thank you to Diversity HR for partnering with us today and for inviting various people along. We do appreciate their partnership on producing today's webinar. We'll talk about key case law updates. So at that point, I will hand over to Lisa, who's going to take you through a whistle-stop tour of some key points of the Employment Rights Act. Is it Employment Rights Act 2025 now? Yeah.
Yes, thank you very much. Good afternoon, everybody. I think we decided that we couldn't do an employment rights update without discussing the Employment Rights Act 2025. It's being described as an overhaul of UK workplace rights for a reason. Many of the reforms are still subject to ongoing consultations. They will require substantive regulations to bring them into effect, but we have seen some changes already come into play as of April. We've got a slide with a timeline on it that shows all of the changes, but as Colin said today, I'm just going to run through some of the changes we've already seen come into effect and some of the more substantial changes we're expecting in the next kind of 6 to 12 month period that really will require some kind of thought and potential action by employers now. So the first of the changes we saw come in as of 6th of April this year are changes to statutory sick pay. The new law scraps the 3-day waiting period. That's no longer required, and statutory sick pay will be payable from the first day of sickness. The lower earnings limit for statutory sick pay eligibility has also been removed. Although to avoid employees receiving more than their normal weekly pay, what the new rules actually provide are that the weekly rate of statutory sick pay you will pay to your employees will be the lower of the prescribed weekly rate, which is currently £129, or 80% of their normal weekly earnings. I think many employees were probably already paying statutory sick pay rates from day one, but for those that weren't, obviously there will be an increased liability. And it's just important that employers check kind of sickness absence policies just to make sure that they're now up to date and reflect the changes in the law. The next change we saw as of April this year was some changes to family rights. So I'm going to refer to parental leave and paternity leave. What the new Act has done is remove the qualifying period for eligibility for these types of leave. So these are both now also day one rights. That's unpaid parental leave and paternity leave, not pay. The new Act also allows for paternity leave to be taken after a period of shared parental leave, which wasn't the case previously. We've also seen changes to the definition of a qualifying disclosure. So that's for whistleblowing purposes. A qualifying disclosure will now also include a disclosure of information that sexual harassment has occurred, is occurring, or is likely to occur. And that disclosure for whistleblowing purposes will still be subject to the existing test. So to amount to a protected disclosure, it still must be disclosed to a prescribed person in the public interest, etc. I think in practice, it may make limited difference. Sexual harassment could already be disclosed as a breach of the law, but it's now included in there explicitly. I think for some employers, it may change the way they deal with sexual harassment complaints. It may be that they do now need to be investigated under the whistleblowing policy if you have one. So that was a quick overview of the changes we've already seen. The next round of substantial changes are currently expected in October 2026, so October this year, kind of 6 months, 5-6 months time. The first of those also relates to sexual harassment, and we're seeing a change in the duty on employers to prevent sexual harassment of their employees. Currently, employers can have vicarious or secondary liability for harassment by their employees if done in the course of employment, and it can also be personal liability if you commit an act of harassment, and that includes sex and sexual harassment. And employers are currently required to take reasonable steps to prevent sexual harassment of their employees. Well, that duty is changing, so that employers will be required to take all reasonable steps. So we've got the all in addition, all reasonable steps to prevent harassment of their employees. The Employment Rights Act 2025 will give the government powers to specify in regulations what amounts to reasonable. We don't have those yet. They're expected in, at the moment, they're saying 2027, 2028. But it is expected that employers will then have to take all of the steps that are specified in regulations in addition to any other reasonable preventative steps. We don't know what they are. It's likely to be subject to type of sector you work in, type of business, workforce, etc. But we expect they would include risk assessments, which many should already be doing, publishing plans and policies, providing staff training, and taking certain steps around reporting systems for these complaints and how you handle these complaints. This new duty, so the duty to take all reasonable steps, actually mirrors the existing all reasonable steps defence currently within the Equality Act. So the preventative duty is consistent with the statutory defence, but whether or not the all reasonable steps will raise the bar for employees is yet to be seen, but we do expect that it's at least likely to raise expectations of employees in dealing with these matters and preventing sexual harassment in the workplace. There's also a new duty on employers that extends to all types of harassment. And again, it's a duty to take all reasonable steps to prevent harassment of their employees by third parties. This is a new duty on employers. Obviously, this is going to be very difficult for employers as they have less control over third parties than they do over people working for them. And of course, the risk is going to be higher for those employers that have staff frequently stood in front of members of the public. So, for example, in the hospitality sector, in the health sector. Again, we don't yet know what all reasonable steps is going to include, but again, it could be things having signs and warnings kind of up on the walls and around, perhaps put in anti-harassment commitments in third-party contracts, and having clear guidance on how these types of incidents should be reported. Moving on to January 2027, many of you have probably already read quite a lot of information, or at least seen kind of communication and commentary around the changes expected to unfair dismissal, and as these are coming in January 2027. Currently, employees have to have 2 years service to bring an ordinary unfair dismissal claim, and if they are successful, the compensatory element of any award they receive is capped. There is a cap of either the lower of the prescribed rate, that's currently £123,543, or an amount equivalent to the employee's 52 weeks' pay. Under the new laws, that qualifying period will be reduced to 6 months. This is for ordinary unfair dismissal claims only. Any current claims of automatic unfair dismissal that are day one rights will remain as day one rights. But it does mean that employees that have at least 6 months service, as at the 1st of January 2027, they will be protected. It's likely that we will see, obviously, an increase in the number of employees capable of submitting ordinary unfair dismissal claims, and therefore an increase in these types of claims. Employers will be faced with an increased workload effectively in having to deal with these cases. It's also going to have an impact on probationary periods. So probationary periods that by quite standard are used of 6 months, they will no longer be advisable. If you use a 6-month period and at the end of that period the employee is not deemed suitable or successful for the role they've been recruited into, they will already have gained ordinary unfair dismissal protection, which makes their dismissal obviously more risky. It will be more costly. So employers do need to consider now using shorter probationary periods, just to allow sufficient time to assess the employee, but also for any dismissal to take effect before the 6-month period. It might be quite difficult. 6 months is normally required to assess an employee in that role, and employers will now have less time to do so, but to allow a 6-month period is going to be, as I said, risky and expensive. Employers should also be looking to train managers on how to effectively manage probation periods and carry out a fair end of probation process, and really now take action on reviewing current staffing levels, identifying employees that have got between the 6-month and 2 years service who are perhaps not performing as expected, and address those now. In January, we're also going to see the 52 weeks gross pay and statutory cap for unfair dismissal claims abolished. So that will be removed. There will be no cap on successful unfair dismissal claims in terms of the compensatory award. There's no change to the basic award. That will, of course, increase liability risk for unfair dismissal claims. It's likely to increase, or we expect it's likely to increase, the number of claims issued by higher earning employees that at the moment perhaps aren't inclined to issue an ordinary unfair dismissal claim because of that cap. And it does also suggest that employers will have to follow a process now in dismissing senior executives, again, when perhaps they haven't done so before and it's more of a conversation. But if they don't do so, compensation awards could be very large. It could also mean that settlement discussions with these individuals and other employees become more challenging, because it's going to be difficult to put an estimate on what an individual may achieve should they proceed all the way to the tribunal and be successful with their claim.
Just one correction on my own slide, because this comes from something I wrote. These were written, this slide was written before the weekly cap went up to £751. So the weekly cap is 751, not 719 now. The maximum overall cap is therefore slightly higher than 21,570, but so just bear that in mind.
Okay, thank you. And then just to kind of highlight some other measures, so we haven't got the time to go through any of these in detail, but again, they are going to need some attention potentially for employers. So one of these is fire and rehire. So these changes again are expected in January 2027, and what the new law is going to say is that dismissal of employee will be automatically unfair if the reason, or the principal reason at least, for that dismissal is that you have sought to vary certain key contractual terms, so for example, pay or hours, and the employee did not agree, or the dismissal is because that employee is being replaced with a non-employee, but to do the same work. So that could be replacing them with an agency worker, for example. There will be an exception if an employer can show they were acting in response to financial difficulties, but we suspect that at the point of employers in financial difficulties, this is all going to be too late. Obviously, the consequences of these changes in the law are going to significantly restrict an employer's ability to use fire and rehire tactics, if you do, to change terms and conditions of employment. So businesses really need to be reviewing current contracts now. Do they offer sufficient flexibility to suit the business now and in the next few years? And if any changes or significant changes to terms and conditions are anticipated that would require this type of practice, you really need to be looking to start that now, given contractual notice periods would need to be served. Another change expected, this is, I can't remember, guaranteed hours. Can't remember whether that's October or January, apologies, but it will be one of the two. But we're seeing some change there. So the new laws, these are quite extensive changes. The new laws will impose a duty on employers to offer qualifying workers a contract that reflects any hours they regularly work. So if you've got employees on 0-hour contracts or minimum hour contracts and they work regular hours over a specific reference period, it's been suggested that may be 12 weeks, but that will be confirmed in regulations, then you'll have a duty to offer them a qualifying contract that reflects those hours. They will also gain the right to reasonable notice of any shifts. That includes the time, day and how many hours they're required to work. And they have the right to reasonable notice of any change to that shift, or if that shift is cancelled. And where they receive short notice of any of those changes, they will be entitled to compensation. Much of the detail around those will be set out in regulations. We don't have that at the moment, but if you do operate with 0 hours or minimum hours contracts, then employers will really need to make sure they've got arrangements in place, processes in place to manage shifts, changes to those shifts, and any cancellations of those shifts.
And if you think you can get around this by using agency labour, my recollection is there are a similar set of rules that will apply for agency workers as well.
Yes.
So that won't necessarily solve or avoid this issue.
Absolutely. Then lastly, the last measure I'm going to just quickly run through is in relation to outsourcing of public services. And this one isn't getting as much publicity as some of the other measures. It's expected to come in October of this year. And what the Act will do is introduce powers to avoid what is known as a two-tier workforce. So it will avoid having ex-public service sector employees and private sector employees being employed on different terms and conditions where we have a public service outsourced. It's expected that regulations may require specified provisions to be included in outsourcing contracts to ensure that workers aren't treated less favourably than their counterparts. This is likely to increase costs for outsourcing providers, and private providers tendering for public contracts really need to be aware of the cost implications and how these new rules will impact their workforce, where they've got incoming and existing staff working on that public service contract. It also isn't clear what happens when that service comes to an end, but they're all points that need some consideration now. Okay, a bit of a whistle-stop tour, but really it's just to highlight what's going on. And we do have some more specific detailed webinars coming up in the next few months. So it's probably worth having a look out for those.
Yeah, we'll be looking into some of these areas in a bit more detail once we have the devil of the detail, which in areas like guaranteed hours and shift pay compensation, we just don't have yet. What we're saying to people at the moment is, what can you do right now with a lot of these future changes? Well, unfair dismissal, you can be aware of. That's happening on the 1st of January. The impact on probationary periods and the design of assessing new employees and whether they're frankly up to the job before you run into ordinary unfair dismissal, additional risk, that you can start thinking about. Third-party harassment, you can start building systems, policies, procedures, ways of trying to put in place reasonable steps, or all reasonable steps to prevent that. These are things you can do now. And the hire and refire we keep going on about, if you've got inflexible contracts, now is the time to think about whether you want more flexible contracts within reason, because there's still going to be something someone will sign, but ultimately it's going to be much, much harder to change contracts, whether it's one individual contract or whether it's 100 contracts. It's going to be much harder to vary those other than by agreement after the 1st of January next year. So when you're drafting new contracts or contracts at the moment is of change, or if in a more dramatic situation you need to vary the existing contracts you have, it's not easy now, but it's a lot easier now than it will be in 6 months' time. We're now going to have a quick look at some recent cases to take a step away from the rather all-encompassing thing that is the Employment Rights Act, because it has sort of taken over all of the discourse lately in employment law, and just look at what the actual courts have been deciding in a few areas that hopefully have some practical application. We get lots of cases that are about procedures and tribunal rules and complex issues that are very hard to bring back to anything from a HR perspective that has a day-to-day impact. These ones are a bit theoretical in places, but they also they raise some interesting issues. McMahon and AXA was a case to do with permanent health insurance, long-term disability insurance, PHI as we call it, okay? And it was about whether or not PHI payments by the employer to the employee of income replacement were or were not wages under the Employment Rights Act. Okay, and I'll come on to why that's of relevance. Okay, but the first argument was whether or not they were due, and if so, how they could be sued for, whether as wages or as damages. It's a bit technical, but it has legal consequences. Miss McMahon started in January 2000. Contract had entitled her to 75% salary under a PHI scheme until normal retirement at 65. So a long scheme. Many nowadays have been reduced to 10 years, some to 2 years, because it's otherwise a potentially long-term liability. AXA was supposed to secure these benefits by insurance, failed to do so due to an admin error. Somebody probably forgot to put her on the right spreadsheet when they renewed it. Yeah, it happens. I've had it happen to some of my clients on life assurance as well as permanent health insurance, and it can be very expensive. She became eligible in 2011, but they didn't pay her because they forgot to insure her. Okay, which is an unusual decision. Many would choose to then pay the payments themselves almost on a self-insurance basis, but they chose not to pay her at all. And ultimately, she brought an unlawful deduction from wages claim many years later when she was dismissed in 2013. Okay, so the issue was, could she bring that as an unlawful deduction from wages claim, not only for 2011 to 2013 when she was still employed, but for the period after 2013 until her retirement at 65 when she wasn't strictly employed. Now, historically, wages claims don't stretch beyond termination. That becomes damages. And for complex reasons, that's harder to bring, riskier to bring, and you can't bring it in a tribunal for more than £25,000. Okay? Wages, however, you can join together in a big, long connected chain going back in time almost indefinitely and potentially going forward in time and bring them in a tribunal without the cost risk, without the cap, because there's no cap on an unlawful deduction from wages claim, but there is on a breach of contract for damages claim. Okay? So the court was dilemmaing over how to do this. And they said, well, we can do it in one of two ways. We can say that the PHI payments become a collateral contract, which is ongoing and survives the termination of the wider contract. It's a bit complex, but in other words, that bit, the obligation to pay the PHI, continues as a standalone ongoing obligation. Or you're not allowed to fire someone for incapacity when they're entitled to PHI. That was established 20, 30 years ago in a case called Aston. Okay, that's been around for years, but what they said is therefore the dismissal doesn't take effect. It's a nullity, it doesn't count. What they didn't really address is if it's a nullity and it doesn't count, and that's why it's wages, what else continues? What else survives until she's 65 in terms of the employment relationship? That was unfortunately left unclear. Okay, but they did find she was entitled to the money until 65, and she was entitled to claim it as an unlawful deduction from wages, not only for the bit when the employment was still live, 2011, 2013, but afterwards, okay? And that is quite a radical change in what wages means. And it opens up a potential can of worms as to what else might subsist and continue in those situations. What it did make very clear, and it distinguished a case called Delaney and Staples, which is to do with payment in lieu of notice, okay? Which it said that that doesn't apply. So this rule still doesn't apply to traditional notice pay claims, but it could apply to things like permanent health insurance claims. Now, if you don't have permanent health insurance, good, lucky you, this isn't an issue. If you do, make blooming sure you've got everybody insured that's supposed to be insured. Otherwise, this sort of case is now going to make the risk higher and the potential risks very expensive. Okay. That is it. But in effect, it comes down to if she wanted to bring a damages claim, it should have been capped at 25k in a tribunal. Bring it as an unlawful reduction wages claim, you can bring it in a tribunal, no cost risk, simpler process, no cap. That was the technical argument, but it opens up a potential can of worms as to how PHI works after termination. If you have those schemes, make sure everybody is insured. Kankanalapali versus Lush Energy, this was to do with offer letters and whether or not an offer letter created a binding contract. Okay, and it's technically about conditions precedent versus conditions subsequent in contract law. Okay, but also about whether you can imply a notice period to give certainty to a contract and give effect to its terms. Okay, and what it said is you have to be careful about not only what conditions you express, but how you express them. Okay. So he was offered a senior project manager role. He sent an offer letter that outlines the key contractual terms, including the role, the pay, the start date. That's quite important because if you don't specify those sorts of key terms, there's not sufficient certainty for there to be a contract, but the key terms were there. The only key term that wasn't there was the notice period. Okay, but the offer was expressed to be subject to satisfactory references, right to work checks, successful completion of a 6-month probationary period. All in one sentence, almost, all in one paragraph, all together, no distinction between those conditions. Okay? Claimant accepted the offer, resigned from his existing job, relocated from overseas to take the role, was offered relocation assistance as part of this whole package. Okay? And then before the employment commenced, the employer withdrew the offer, saying we've got project delays and internal business reasons. And the employer sought to argue there'd never been a contract. Therefore, nothing was owed. No notice was owed, no pay was owed, because we hadn't reached the point of reaching a binding contract. Okay? The employer said, no, the employee said, we've got a binding contract and I'm entitled to a reasonable notice, whatever that's decided to be. Okay? The ET said, no, there are preconditions, they've not been satisfied, no contract. Off it goes to the EAT. They had to decide, well, was there a binding contract, notwithstanding the conditions that were expressed in the offer letter? And if so, what notice period applied? Okay. And what they looked at is this concept of a condition precedent, which is a condition that stops the contract being formed until it's satisfied, and a condition subsequent, which is a condition of the contract once it's formed that might permit it to be terminated. Okay. So that's the difference. Condition precedent means no contract arises. Condition subsequent just gives you a basis to terminate it. Okay. And what they said is the offer letter in this case didn't expressly say no contract will be formed until the conditions are satisfied. First thing you ought to put in offer letters if you want conditions precedent. These are conditions precedent. A contract won't form until they're satisfied, therefore. Yeah. And what it also said is that one of the conditions, the probationary period, could only be satisfied once it had begun. So it couldn't be a condition precedent. It had to be a condition subsequent. That makes perfect sense. But what they also then said is because, unfortunately, you wrote all three conditions together without distinguishing between them, we have to interpret them consistently. Therefore, we're going to treat them all as condition subsequent, not precedent. Therefore, there's a binding contract. Therefore, you owe him reasonable notice, because you've terminated the contract in breach. Okay. And although there's no notice period, we can imply reasonable notice when it's necessary. That's always been the case. What it also pointed out is that minimum notice periods under the Employment Rights Act are a minimum, not a maximum, and they're not necessarily the same as reasonable. So the fact he's only due a week under the Employment Rights Act doesn't mean he's only due a week. And what they said is we'll look at the seniority of the role, the length and the seriousness of the recruitment process, the international relocation, the rearrangement of the accommodation, the fact they were paying for relocation. They took into account all of these factors and said 3 months is reasonable in that case. The learning from it is be very careful with offer letters if you don't intend to create a binding contract until subsequent conditions have been met. You need to be very clear and very precise in what you're saying, how you're saying it, even the layout and the structure of the letter, if you want to distinguish between a precedent that says you must tick this for a contract to form and a subsequent, which is once it's formed, we can terminate if this isn't met. Okay. Conscious of time, I've got just about time just to cover this one. This one was called LR'd and it's to do with collective redundancy laws. Okay. And it's the most recent case in a long number of cases that get themselves into a right state of confusion about when you trigger a collective redundancy process. One of the changes that's come in under the Employment Rights Act that Lisa didn't have time to cover is that the penalty for failing to follow collective redundancy laws correctly was 90 days per affected employee. It's now 180. It makes failing to do collective redundancy correctly one of the potentially most expensive cock-ups you could make. Yeah, because half a year's pay for 20, 30, 40, 100 employees could be a lot of money. Okay, so when you have to trigger these duties is important. The other reason is that one of the other Employment Rights Act changes that will be coming down the track is the widening of the concept of establishment. Historically, at the moment, collective redundancies are, broadly speaking, one geographical location. Okay, 20 or more at one location within a period of 90 days. Going forward, there is going to be a new threshold, yet to be finally set out in regulations, that can be applied across locations within an organisation. And that means organisations are going to have to keep an eye on what they're doing in terms of proposed redundancies across multiple sites, and at some point figure out whether across multiple sites they are proposing 20 or more, thus triggering these rules. And if they get it wrong, it's now twice as expensive. Okay. What this case basically said is that what they tried to argue is we went into administration. On the 2nd of May, we absolutely clearly proposed 15 redundancies. We didn't propose, in theory, the remaining, I think it was 46 or remaining 36, sorry, on the 5th of May. If you take the 2nd of May and the 5th of May together, you have 20 or more within 90 days. What they said was, well, on the 2nd of May, we weren't proposing the 5th of May because we thought we were going to still sell the business, therefore those weren't being proposed. Unfortunately, what the evidence quite categorically showed is that on the 2nd of May, they knew they were dead. Even the administration process said, we can't save this, we know we're dead. So the evidence was we're dead, yet they said on the 2nd of May, we aren't proposing what then happened on the 5th of May. Unsurprisingly, what the court said is, look, the proposal, you have to look at the proposal on the 2nd of May and say, basically, what is most likely to occur here? Is it likely you are going to be making these redundancies within a period of 90 days? Yes, therefore you trigger the collective redundancy rules, I'm afraid. The fact that the 5th of May wasn't absolute until the 5th of May doesn't matter. What matters is that you have a reasonably certain proposal on the 2nd of May that could exceed those thresholds of 20 or more. Okay, the best way that I can put it, just skipping a couple of slides that you can obviously read through because we will be sending you these, is, where are we? I just want to get to the one that shows you what I think was the best way of phrasing it in terms of the test. 2 seconds. Basically, what it says, in the context of a closure of a business, dismissals are proposed when closure is proposed, not mooted as a possibility. So the first point, it's been law for years, you're proposing a closure, not when you've absolutely decided it, when it's a proposal, standard redundancy sort of practice, but where it is a fixed, where it is fixed as a clear, albeit provisional intention. Okay, so you have a proposal where you have a fixed, clear, albeit provisional intention to make redundancies, not necessarily an actual final decision to close something. But it's going to become an ongoing issue when we widen this concept of establishment, because you're going to have to keep a watching brief on job cuts across multiple sites and figure out at what point you were supposed to know you had a reasonably clear proposal that would add up to 20 or more in the next 90 days. Conscious that's been a fairly whistle-stop tour of stuff. I'm conscious we have a 40-minute session today rather than the usual 30 minutes. So we have actually managed to leave some time for questions. If people have questions, now is your opportunity to type them into the questions box. We will try to answer the ones that we can. Obviously, if they're specific to your business, bear that in mind in terms of what you might type, because we may read it out. Someone's asked, will we be sending a copy of the slides? Yes, there'll be a copy of the recording made available with the slides in it. So obviously you can listen back or look back and go through the services. You've seen there's more detail in some of the slides that we've skipped over in order to get through the material today.
I think as well, as I said earlier, the next few webinars will be focused on more detail on some of the Employment Rights Act proposed measures. So it's worth kind of keeping an eye out for those, or subscribing to those if you aren't already. You'll get the prompts as to what the next webinar is and how you can join that. Yeah,
we've been asked, how do I suggest you set out offer letters carefully? With all flippancy aside, I personally am a big fan of not sending offer letters as such. And what I mean is, if I'm offering someone a job, send them the contract. If you're negotiating, that's a different thing. You've got to be careful about that being subject to contract, so that you don't reach an agreement in negotiating bits before you mean to. So if you're discussing back and forth an offer, make sure everything is subject to contract, and then at least you've got the safety net of going, nothing's agreed until it's in a proper contract. Okay. Once you've got terms agreed and you want to set them out and say, here's an offer them the contract if you can, because then everything should be in it, assuming you have a good contract. If there are then conditions precedent to that contract forming, you put them in the offer letter. In other words, what's in the offer letter are the conditions precedent, what's in the contract are any conditions subsequent, because they're part of the contract. I hope that makes sense. So I'm a big fan of, wherever possible, give them the contract, because it should then avoid things being missed in the process.
Probation periods, that's probably going to come up quite a lot, isn't it?
Probationary periods, what do we suggest is a suitable probationary period, given that 6 months generally won't work? Something shorter than 6 months. Generally speaking, 6 months doesn't mean 6 months, because we suspect it will mean 5 months and 3 weeks, because you extend periods by statutory minimum notice, which will be a week. So bear in mind, 5 months. 5 months is a doable one, but if you miss it, it's a very short time window to slip into 6. Some are going with 4, some are going with 3, some are abandoning the thing altogether and going, well, it's become rather pointless, so we'll just manage people and deal with it on an ongoing basis. It's a matter for your individual business. For some businesses, 6 months isn't really enough to train someone, develop them, and really know whether they're going to be good enough, and therefore stick with 6 months and just accept that unfair dismissal will apply. For others, they move to 3 months, because in our job, or whatever this job is, we'll know in 3 months whether they're frankly up to the job or not. It's hard to give a better specific period. It can vary depending on the job.
I think just on that point about the statutory notice being added on, so it's just important to bear in mind that dismissals in the last week of a 6-month probationary period will not cut it anymore, because there is that additional notice period added on that will get them over the 6-month mark.
Yeah. Someone's asked about administration, what happens to ETs? In simple terms, when a company goes insolvent into a formal insolvency process, ETs are subject to a moratorium. They basically get stayed pending what happens in the insolvency. So they generally get parked, and then ultimately, quite often, they die because the insolvency brings it all to an end. Somebody's also asked about the establishment point. Is that just one company, or is that across an organisation? The honest answer is I don't know, and I can't find a clear answer. It's going to apply across different locations. I'm currently unclear on whether that will apply at a group level or a company level. At the moment, the rules only apply at an individual legal entity company level, not at a group level. But I'm waiting for the devil in the detail to be able to answer that one. Someone's also asked about union rights. There are, within the Employment Rights Act, the Employment Act 2025, there are a lot of new union rights. There are a lot of changes to the compulsory recognition procedures that make it easier to obtain compulsory union recognition. There are also rights to allow access to your premises virtually or physically for unions to come on site and try to drum up interest in union membership and potential collective recognition. If you're not aware of those, it's worth keeping an eye out for material on that and being aware of these rights in case trade unions now approach you, seeking to come on your sites, seeking to come and talk to your staff about trade union recruitment and so on, because there are going to be much stronger rights for unions to do that. How much capacity trade unions have to be running around the country doing that is a different question. But if you are in an area where you've had unions pushing for recognition, it's going to become harder to push back, is the best I can put it, because they're lowering the bar for compulsory recognition applications. I think we've exhausted the questions, and we are at the end of the proposed time for today. Thank you for attending, and thank you for your questions. I hope it's been of some use. There's obviously there's a whole raft of things within the Employment Act that are bringing in changes both in October, already brought in April, and in January. We will continue to do updates through webinars and through our website and through our articles and so on and so forth. So do keep an eye out. We'll keep bringing you more information on these proposals as they come. My fear is some of the detail has a habit of coming a week before the new rules tend to come into force. But at least if you've got some idea what's coming, you'll have some ability to prepare in advance. Otherwise, I will say thank you for today. So as they used to say in one comedy show I've forgotten, it's goodbye from me. And it's goodbye from Lisa as well. So thank you for coming today, and we'll call it a day at that point. Thank you.
Thank you.